This is the State of Wisconsin versus Brendan Dassey 06CF88. Appearances, please count.
The state appears by Calumet County District Attorney Ken KRATZ, appearing as special prosecutor in the case. Joining me this afternoon is Tom Fallon from the Department of Justice.
The defendant appears personally with attorney LEN KATCHINSKY.
All right, we last were here in this courtroom Friday, May 26th last week. At that time, we had scheduled here a motion on bail, actually two competing motions on bail. One from the defense asking that the property be allowed to be posted as surety for bail in this instance, and the other from the prosecution asking that actually bail be increased. At the commencement of that proceeding, I asked Mr. Dassey whether or not, because it had been discussed in chambers prior to coming here, whether or not he desired new counsel. In response to that inquiry, he told me he did. At that point, I adjourned the hearing to come back here today to flush out the record specifically by finding out from Mr. Dassey what his objections to court counsel were, if any, and whether or not those objections rose to the level that substitute counsel would be appointed. Does this comport with your understanding, gentlemen? First, you, Mr. Kaczynski.
Yes, Your Honor, it does.
Special Prosecutor.
Yes, Judge.
Mr. Dassey, would you pull that microphone a little closer to you, please? Remember, at the last time you were in court, I asked you whether or not you wanted someone to replace Mr. Kaczynski.
Yeah.
And you responded at that time that you did.
Yeah.
Is that your answer today? If I were to ask you the same question, do you want someone to replace Mr. Kaczynski, what would your answer be?
Yes.
How do you get along with Mr. Kaczynski?
Not bad.
Does not bad mean good or what?
Yeah.
You guys fight when you're together?
No.
You argue?
No.
Can you talk with him?
Yeah.
Does he listen to you when you talk?
Yeah.
Does he explain things to you?
Yeah.
Does he explain things to you in a way that you understand them? Are you still talking to him?
Yeah.
Do you think he's doing what he believes to be in your best interest?
Sort of.
And sort of mean yes, no, or a little of each?
Little of each.
You think he understands your case?
Yeah.
Is there any way in which the two of you are in any serious conflict, any serious difference of opinion?
Not that I know of.
Tell me why you want to change lawyers at this point.
Because I think he thinks I'm guilty.
And that's the reason that you want to get a different lawyer?
Yeah.
Did someone else bring this up to you, the notion that you should have a new lawyer?
Just my mom.
And she urged you to find different counsel?
Yeah.
Is there any other reason other than the one that you have given to me that you think Mr. Kaczynski should be replaced by someone else?
No.
All right, Mr. Kaczynski, you have filed an affidavit to which you've attached, or I shouldn't say attached, but you've also filed at the same time a short Memorandum of Law. I'm going to just touch upon a couple of the items that are in your affidavit. Although we all understand that since the affidavit's been filled, it's a matter of record. You note in the affidavit that you are approximately one of 4 lawyers in Wisconsin certified as a criminal trial specialist by the National Board of Trial Advocacy. Is that correct?
Yes, Your Honor.
What is the National Board of Trial Advocacy?
The National Board of Trial Advocacy is an APA-certified organization that tests attorneys that wish to apply for certification so they can place it in advertisement and other purposes in their state, Under state codes. They have to be qualified as a criminal trial specialist. There's requirements for a certain amount of jury trial experience. There's also educational requirements in terms of continuing education requirements for references, and also a check with the reputation among the local judges. Based on that, then they'll they'll certify you. They also have certifications for other types of specialties, such as civil trial specialties and family and probate law.
Just for the record, ABA means American Bar Association, doesn't it?
Yes, Your Honor.
In your opinion, is this an honor to be certified by the National Board of Trial Advocacy?
It's not so much an honor as it is just a recognition of considerable experience and a certain level of talent in the area.
According to your affidavit, as of May 26, 2006, you had spent over 140 hours representing Mr. Dassey. Is that correct?
Yes, Your Honor.
You have hired an investigator to assist you in the preparation of this case, have you not?
I have, Your Honor.
You note in the course of the affidavit on page 2 that there has not, at least in your opinion, been a breakdown of the attorney-client relationship.
Correct, Your Honor.
This affidavit is dated May 30th. That isn't long ago. Has there been any changes in that?
I talked to Mr. Dassey earlier this week or month, I don't know anymore. The tone of our discussion was the same as it was before, pretty much as he just described it to the court.
All right. You say as well that Mr. Dassey appears to understand the issues in the case on the intellectual level. Is that correct?
Yes, Your Honor.
And that your interaction with him, the tone of your conversations, has generally been casual and relaxed?
Yes, Your Honor.
Has there been any irreconcilable differences between the two of you?
Not at this point.
Have you received any notice of retention of private counsel for Mr. Dassey?
I have not, Your Honor.
Are you, in the event Mr. Dassey so desires, prepared to try this case on his behalf?
Oh, yes, Your Honor, I would be.
All right. That ends the court's inquiry, and I'm going to rule. Mr. Dassey has requested that he have substitute counsel appointed for Mr. Katchinsky. In order for that to occur in Wisconsin, the defendant in this case, Mr. Dassey must show that there exists a factual basis for appointing a successor counsel. In fact, the defendant who has appointed counsel, which is what Mr. Katchinsky is, must show that there is, quote, good cause and, quote, to warrant substitution of his current lawyer, and that's set forth in a number of Wisconsin cases. I am taking it for this hearing from the case called State versus Haynes at 118 Wisconsin, second page 21 at page 27. Another case sets forth a number of examples of good cause. In that case is State versus Wanta, and that's 224 Wisconsin 2D 679 at 703. Now, I'm not suggesting that these are exclusive examples or illustrations of good cause, but frankly, and I think I've read almost all of this, all the cases that touch on this, I haven't really seen any cases that embodied other than these facts or these examples I'm about to run through. One of them is attorney incompetency. Another is conflict of interest between the lawyer and client. Another is irreconcilable conflict of difference. And another is that complete breakdown in communications between the lawyer and his client. Additionally, the case sounds a cautionary note by pointing out that exchanging or substituting counsel can be manipulated in such a way as to interfere with the administration of justice. So, where does it get us based on these facts and using the legal standing that I said applies here? Now, let's look at attorney incompetency. Here we have a lawyer in Mr. Kaczynski, who is one of the handful of Wisconsin attorneys who is certified as a criminal trial specialist by an acknowledged national board, namely the National Board of Trial Advocacy. He spent over 140 hours since his appointment on this matter in early March of 2006, preparing the case. I've had the opportunity to evaluate not only his court appearances, but his written product, brief, motions, pleadings, and I don't think anyone would even remotely suggest that there has been any showing here of incompetence. Conflict of interest between a lawyer and a client, I don't think that exists. There is not even a threshold question. By way of illustration, Mr. Dassey originally had an attorney who determined at one point or another that he was related to some members of the victim's family in his case, and that's a conflict of interest. Obviously, he requested that he be removed. That was good cause on his part to be removed, and he was removed and replaced by Mr. Kaczynski. The next one is irreconcilable conflict of difference. I don't see or hear anything that tells me that irreconcilable conflict of difference. Mr. Dassey says he has some reservations about counsel because of Mr. Dassey's perception of what counsel may or not think about his guilt. Well, that in and of itself, and there is a case law on this, does not constitute good cause. It also is part, I would suggest, of a substantial number, if you're not a majority of criminal law cases. So I don't think that there is any irreconcilable conflict of difference. Lastly, for purposes of this discussion, I'm going to use the factor to complete the breakdown in communication. There didn't seem to be much, if any, breakdown. There may be a difference of opinion about one thing or another, but here Mr. Dassey was very candid. Said he could talk to him. He said Mr. Kaczynski explained things to him. That appeared that Mr. Kaczynski's take on it is that the relationship is pretty cordial. Mr. Dassey did nothing to gainsay that. So there certainly isn't, I don't believe, any breakdown, complete or otherwise, in communication. With that said, the court is going to find that there has not been good cause shown for substitution of this attorney. Accordingly, I'm going to treat this request as a motion. Accordingly, I'm going to deny Mr. Dassey's motion to substitute someone for Mr. Kaczynski as his counsel. Now, we started out on May 12th discussing one bail motion. The matter was set for a hearing. The defense was prepared to proceed. The defense actually started to proceed. I think we marked the exhibit number 1. During the course, or actually at the very beginning of the process, special prosecutor raised an objection to proceeding and said that prosecution wanted to file a motion asking that bail be increased in this instance. The defense motion was to use property owned in Marinette County by the grandparents of this defendant as a property bond surety for the defendant's $250,000 bail. The property, according to Exhibit 1, had been appraised with their fair market value of $352,600. The local tax authorities had valued it at $332,600. It is owned by Alan, and Dolores Avery. The special prosecutor, after the hearing, filed on May 17th a motion requesting that the bail be raised from $250,000 to $500,000. The motion was received under seal. After reviewing that motion, the court sees no reason why the motion should remain under seal. The court is going to lift that portion of its order that placed the motion under seal. I'm also going to request that counsel, when he talks about this motion, discusses the factual basis for the items or for the material found in it. I should note as well that Manitowoc County, through its Cooperation Counsel, Stephen Rollins, has written a letter that is a matter of record in this court, requesting that the court not grant the motion of the defendant, specifically the defendant's motion envisions Manitowoc County as being the mortgagee for a mortgage that would be taken against the property in Marinette County. Gentlemen, I have accurately summarized. I'll start with you, Mr. KRATZ. Summarize the issues that's here before the court today.
Yes, Judge.
Mr. Katchinsky.
Yes, Your Honor.
All right. What I'm going to suggest we do is, Mr. Katchinsky, you should make whatever argument you want on your motion. Mr. KRATZ, you can respond, and following your response, make an argument on your motion, and you can reply to his response. Go ahead.
Well, Your Honor, we've asked the court to permit Mr. Dassey to be released on a property bond, and we certainly acknowledge the concerns expressed by Corporation Counsel Rollins about a property bond not being as easily dealt with in the event that there's a violation and they wish to fork out the forfeiture of the bond because it is real property and not cash that can simply be moved from one account into another. And that because of those logistical problems that would exist in terms of ever forfeiting the bond should there be a violation or desire by the state to do so, is why we suggested that the amount of the lien be $300,000 rather than $250,000 to compensate for possible attorney's fee and other costs that Manitowoc County might have in the event that that the state had to foreclose the bond because of a violation. I think in terms, though, of securing Mr. Dassey's presence in further proceedings and compliance with the conditions of bond that basically tying up his grandparents' property in Marinette is just as effective as tying up $250,000 in a trust account that's managed by the clerk of courts of Manitowoc County. The property involved, unlike the property in this county, which is a salvage yard, doesn't have nearly the environmental concerns that would exist when Steve Avery made a similar motion in his case, which the court is well aware of. And in fact, the paperwork we submitted to the court regarding the form of the mortgage, etc., was taken from the case. It provided to us, with the assistance of Stephen Avery's attorneys, I believe by increasing the amount of the bond and tying up that significant amount of property, which had been valued higher than the present bond, that it's quite realistic to believe that would serve as a significant incentive for Mr. Dassey to comply with the law, show up in court, and not violate other terms of bail should the court grant that. He's a 16-year-old with community, plenty of community ties, and someone who feels a great deal of affection towards his grandparents, and wouldn't, I think, with any malice or forethought, do anything that would cause them to forfeit property worth over $250,000 up in Marinette County. guilty.
Mr. KRATZ.
Thank you, Judge. Some of the factors that argue against a property bond also argue for the increase in the cash bond. I will defer to Mr. Rollins, as he's much more familiar with the process by which a property bond is converted to cash. Since the value of the property remains an open question, Mr. Rollins's opinion, I think, should be given a lot of deference. The primary factor, however, is that the state believes that property, rather than cash, would be insufficient to secure Mr. Dassey's appearance at future court appearances, and therefore cash should be required. The grandparents, if they're so inclined, have the ability to go to a bank, and if the property is really worth what it's worth, they can convert that property by the way of mortgage to cash and have that posted. But the property not belonging to Mr. Dassey himself, the state believes is insufficient to secure his appearance at future court appearances. That, of course, is the primary purpose of bond under Chapter 969. That is to secure future court appearances. And because of the nature of the offense, because of the risk that I'll talk about in just a moment, the state agrees with the Corporation Counsel for Manitowoc that the property bond is insufficient, and the court should require that it remain a cash bond. Cash bail, however, sometimes is necessary to secure appearances. That has been already determined by this court. The factors that the court considers when determining the amount of cash bail includes the gravity of the offense and the penalties the defendant faces if, in fact, he's convicted. Those, by the way, haven't changed since our last time here in court. But the court should also consider the degree of violence involved, the character and strength of evidence. This court, as I heard this afternoon, has ordered the state to release the information by way of factual basis that we've included in our motion. And I will do that at this time because the new information that's been developed does go not only to the degree of violence that's involved in this case, but also to the character and strength of evidence. First of all, this court ruled on the 1st of March that the statements given by Brendan Dassey, or should I say the statements that he made on the 1st of March, are in fact admissible. As I argued previously, that solidifies the relative strength and position of the case as far as proceeding. However, I've also included for the court, by the way of specific information in my motion, that there have been new forensic findings, specifically in a report received by the DA's office. The report is dated the May 8th, has been shared with Mr. Katchinsky and also counsel in the co-defendant's case. This court is now aware that on the 2nd of March, bullet fragment was recovered from the garage of the property belonging to Stephen Avery. This court may recall that in Mr. Dassey's statement, Mr. Dassey's admission, he indicated that Mr. Avery, as part of the taking of the life of Teresa Habak, used a firearm in the garage area. With that statement having been given, this court is aware that a search warrant was sought, was obtained, and was executed on the 1st and 2nd of March at the Avery property. And in the Avery garage, as I mentioned, a bullet fragment was recovered. That bullet fragment was submitted to the Wisconsin Crime Laboratory for DNA analysis. And in fact, a DNA profile was recovered from that bullet fragment. We know that Teresa Harper's DNA was found on that bullet fragment taken from the garage area. That, of course, is significant evidence, significantly corroborates Mr. Dassey's statement as to the manner of homicide, and it does go directly to the strength and character of the evidence. Mr. Dassey also mentioned during his admission on the 1st of March that Mr. Avery opened the hood of Teresa Harper's SUV. Thereafter, law enforcement officials processed the hood latch of the SUV. Again, a DNA profile was developed from the hood latch and was found to be a positive match for that of Stephen Avery. Once again, Judge, there are new forensic findings that corroborate not only Mr. Dassey's statement, but go to the strength of the evidence that is available to the state. Lastly, Judge, there was a new statement provided by Brendan Dassey to law enforcement officials on the 13th of May. After this court ruled on the 12th of May the admissibility of Mr. Dassey's statement, Mr. Dassey, while inviting law enforcement to meet with him, provided new and important details as to the homicide and surrounding circumstances. Mr. Dassey himself, on the 13th, indicated that he and co-defendant Stephen Avery planned the homicide of Teresa Harper. That is, that they targeted Teresa Harper several days prior to October 31. He and Mr. Avery met, discussed not only the manner in which the homicide would occur, but who the victim would be. They targeted Teresa Harper, and in fact, as Mr. Avery's initial statement, as Mr. Dassey's initial statement may have suggested, that he simply walked into a circumstance on the 31st out of Mr. Dassey's own mouth on the 13th of May. We now know that that wasn't true. This was a premeditated act. Didn't just happen across this crime being committed. Mr. Dassey, on the 13th also, indicates that the location of the homicide was the garage rather than the bedroom. Which again provides in more detail as to mechanism and location of death. And finally, more details were provided as to mutilation of the victim's corpse. This court has to consider, when deciding what the appropriate amount of cash bail to be, risk. There is a risk of flight that the state argues has increased. There's a risk of harm, not only to Mr. Dassey himself, by himself, but from others not wishing Mr. Dassey to be available to testify, if necessary, in future court proceedings, not just his own, but in other matters that he may be required to testify in. Risk of manipulation from external sources, tampering with the attorney-client relationship, decisions that are helpful to persons other than Brendan Dassey. I think Mr. Katchinsky's already alleged and is a risk that this court can and I think should consider. Lastly, the risk to the general public is something the court can and should consider. Given now Mr. Dassey's statement that this was a premeditated crime, that it was planned, that they targeted the victim, the violence and the cruelty exhibited in the series of events, the state believes, now requires or justifies the court increasing cash bail from $250,000 to $500,000. The state believes that amount necessary to secure Mr. Dassey for future court appearances. That's all the state has, Judge. Thank you.
Mr. Katchinsky.
Your Honor, in terms of whether or not the present amount of bail is sufficient or not to assure Mr. Dassey's presence at trial or to ensure compliance with the issue of bond, the court needs to compare the circumstances that existed at the time it was originally set when he was arraigned on March 3 of this year to the present, and to see what the new evidence has been cited by Mr. KRATZ really adds in terms of the likelihood of conviction and eventual sentence based on to Mr. Dassey. When Mr. Dassey first appeared before a court and bond was scheduled at $250,000, the court was aware, and it was contained in the criminal complaint, that there was a videotaped confession that was sufficient to support the 3 charges that were in the complaint. Confession, of course, if it's valid and jury believes it and doesn't believe that it was coerced or the result of some type of coaching by law enforcement officials, this is probably about the strongest type of evidence you could ever have in a criminal case. There were, of course, at that time other circumstances that would tend to perhaps show that Mr. Dassey was the perpetrator of these offenses in terms of his location at his residence, his presence in the area around the time of the offense, and so forth. The question is, does this new evidence cited by the state really add very much to that? It doesn't really change any evidence that didn't already exist, that Mr. Dassey lived in the vicinity of Mr. Avery, knew Mr. Avery, or that Mr. Dassey had made statements on videotape claiming to have been involved in the offense that Mr. Avery had previously been charged with. His character before the bond was originally set was someone who never had any contact with law enforcement other than previous meetings with law enforcement officials in connection with this investigation. The court saw those later on when the motion to suppress was litigated, and it really doesn't add very much to that as well. Whatever degree of planning may have existed, it's still rather clear that the impetus behind this was that it did occur that Stephen Avery and not, what's his name again? Brendan Dassey. The relative ages of the individuals are known by the court. The court has seen Mr. Dassey's interaction with others in those videotapes, which the court reviewed in the motion to suppress, to see that Mr. Dassey is not someone who's a leader or aggressor in terms of violence against other individuals. I don't believe that the state's additional evidence has added much to beyond what already existed at the time bond was originally set. So we'd ask that the bond amount remain where it is.
Alright, the court has before it two motions, and I'll treat them as they came in. First is a motion on the part of the defendant to be permitted to use as surety for $250,000 bail property in Marinette County that has been valued at, I think it was between $330,000 and $350,000. The defendant proposes executing a mortgage in favor of Manitowoc County in the sum of $300,000 to secure Mr. Dassey's $250,000 bail. As both counsel have noted, bail setting is something of a balancing act under Wisconsin law. Specifically, under Chapter 969, our statutes, the court is setting bail here has taken a look at the nature, number, and the gravity of the offense, the potential penalty the defendant faces, and the violence of the acts involved, and came up as a result of that with bail of $250,000. The statute permit under certain circumstances that property be posted in lieu of cash, and that is precisely what the defendant is proposing to do in this case. It's not the defendant's property, it's its grandparents' property. And that becomes part of the calculus in here, but not, from my perspective, a great part of the calculus. I believe that under the case of State of versus Gasson at 143 Wisconsin 2D 761, specifically at page 763, the court is permitted to reject the use of a surety bond in lieu of cash, and the court can base that rejection, and I'm going to do so, on the seriousness of the offense, the severe possible penalties, and under those circumstances, I think in this instance, cash is going to have to be necessary. Therefore, I deny the motion to lower bail. Now, Mr. Mr. KRATZ has filed a motion, and he has asked for an increase in bail from $250,000 to $500,000. 969.08 of the statute, the title of it says, grant reduction, increase, or revocation conditions of release. Subsection 2 talks about violations of the conditions of release or the bail bond constitutes the grounds for the court to increase the amount of bail or otherwise alter the conditions of release. Now, I'm not suggesting that that's the only time. Obviously, that no one can do this because there are other instances. However, I think that there has to be some significant change, at least arguably significant change in the matter before I'm going to be granting an increase in the bail. In this case, the special prosecutor has told us that they have since discovered forensic evidence that tends to support, I suggest, some of the admissions made by the defendant, and also tie together a little bit more completely the case, and as well, the defendant apparently has made some other admissions. While this is true, and from the standpoint of the texture of the case, it changes, I don't think qualitatively, the case changes. The same crimes are being charged, same penalties are the defendants going to be subject to the same penalties. I don't think, in short, that the grounds offered here today by the special prosecutor constitute significant grounds to increase the bail, and accordingly, I'm denying the special prosecutor's motion as well.
Judge, should the defendant be in a position, whether himself or more typically by a family member, wish to post cash bail, is the court going to fashion some non-monetary conditions of bond that might be appropriate because of the threats that I mentioned about manipulation and other factors? The state believes things like place of residence, other conditions of release all become important. And should that eventually occur, I would simply ask that the state be given an opportunity to be heard by the court in fashioning a non-monetary condition.
And that may well be the case, and you'll certainly have a chance to make that motion. Anything else from you, Mr. Kaczynski, today?
Now, I would agree with Mr. KRATZ that if the bond is posted, there should perhaps be a hearing held very promptly to determine if there's any additional non-monetary conditions that ought to be set.
All right. Each of you can draft the order denying the other's motion. Anything else today, gentlemen?
Nothing, Judge. Thank you.
All right. We are adjourned.